All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. We'll proceed now with the first case on today's docket, Wilcox versus the state of Florida. Counsel?
Thank you. May it please the court. Good morning. My name is Paul Callil. I represent Darious Wilcox. This is an appeal of the summary denial of an initial Rule 3.851 motion by the Circuit Court. Mr. Wilcox was denied any reasonable or really rational opportunity to argue this motion, which is a denial of due process. He was not given any opportunity to argue this motion at all. Going back 3 decades since Huff and since before Huff, this court has required that circuit courts, at a minimum, have a hearing after a Rule 3.851 or Rule 3850 motion is filed. For reasons that I can't fathom, the circuit court here allowed us to amend our initial Rule 3.851, set a Huff hearing, allowed the state to file their response.
Counsel, let me ask you, if for whatever reason, and I'm not saying it's the case, but for whatever reason, all of your substantive claims were completely frivolous and conclusively refuted by any doubt on the record, then the failure to hold a Huff hearing would be completely harmless. Would you agree?
I would not agree.
Why is that?
Because the Huff hearing is fundamental to due process. And this
Isn't
court
due process simply the opportunity to be heard and to file paperwork with the court?
No.
How's that not the case in federal court? There is almost never a hearing on most post-conviction motions.
But when federal courts review what we do here, they say that this procedure is not acceptable. I mean, there's a specific
not as to conclusively refuted by the record or frivolous claims. I guess my question is, if in a 2255 in federal court there is completely frivolous claims and there's no hearing by the trial court, there is no constitutional due process that I understand at the federal level for having a hearing on frivolous claims. Is there? Are you aware of any case that would say that?
I'm not aware of that. I will say that in addressing the 11th Circuit in addressing Alabama capital cases has said that they disapprove of this procedure of courts just summarily denying without an opportunity to be heard. And I'm sorry that the name and citation of the case escapes me, and I'm happy to provide it at another time if the court would like. But this is exactly the type of due process violation that this court and other courts have said the district courts wouldn't have allowed.
So I just want to be clear. So after the opportunity to amend, so after SPERA, you've had your opportunity to amend, your claims are finalized, everyone agrees that they're all frivolous. A trial court is required to bring you in to hear you out on your frivolous claim just to deny a frivolous claim.
Well, you can't determine that the claim is frivolous until we're heard on it. That's the process.
How's that possible? The whole point of the pleading is for you to frame your claim, to present anything that's there. If the state's ordered to respond and responds and it's conclusively refuted by the record, in every other 3.850, there would be absolutely no requirement to have a hearing. But you're saying here we are required to have a hearing?
Just because the state says that the claims are meritless or frivolous.
No, I'm saying everyone agrees. Even you agree that the claims are frivolous. Wouldn't it be harmless?
I wouldn't file claims that I thought were frivolous.
I know you wouldn't, but assuming there is an attorney out there who would file something on behalf of their client that had less than at all merit, and everyone agreed that's the case, you're saying you're still required to hold a Huff hearing?
The rule requires it.
I know the rule requires. There's clearly an error here. My question is that error harmless?
No.
May I ask a question regarding, is it your position that only a hearing is required or an evidentiary hearing?
My position is that the rule is very clear that an evidentiary hearing is required on all claims that require a factual determination. But we're not even at that point yet.
But not for a successive hearing.
Well, not in a successive, but of course this is an initial.
No, I understand that, but I just want to make sure that you're not making that allegation as to successive motions.
That's not the case here, no.
Well, is it your position? I'm sorry. Go ahead.
I just want, what reason did the judge give for not granting a hearing?
He didn't give any reason.
I'm sorry?
I mean, the order is a one sentence that the court has adopted the, I don't want to misstate it, but essentially the court just attaches the state's pleading and says, for the reasons in the state's pleading, I'm denying the motion. But of course, the state conceded that we either get Hearst relief or we should get a penalty phase and effective assistance hearing. So clearly this order is, respectfully, it's not worth anything to this court. I mean, there are no findings whatsoever. It simply relies on the state's pleading, which is improper. This court has said that many times. And it's unfathomable to me that the court would know. I mean, this is an experienced judge. He knows.
We don't, in other words, I want to go back to my line of inquiry. We don't have to, and I think what I hear you saying is, we don't have to hold a due process violation here. We simply have to hold that the error in failing to hold a Huff hearing is prejudicial error in this case because the state conceded that a hearing was appropriate with regard to at least Hearst relief and with regard to the ineffective assistance claims.
I believe that that is a given. However, I do believe that this is a...
We don't need to decide that, correct? The due process issue?
If the court wants to send this back for a full Huff hearing, I suppose it doesn't matter.
Well, your first claim is that there was error not holding one. I get what I'm saying is that error is harmful in this case, you're saying, as I understand it, because the state conceded that at least two of your claims had merit to them.
Well, that's part of it, certainly, but it's harmful because we should have an opportunity to go before the court of first instance and argue our legal claims and our factual claims and have that court make a determination as to whether we need factual development, and then to enter an order, that makes specific findings, that states its rationale, or that attaches portions of the record that refute the claim. None of that happened here. Huff is about due process. Rule 3.851F5 is about allowing an opportunity for the defendant, the appellant,
But again, I think Justice Luck's question was, we don't need to decide that issue whether or not it's fundamental error or it's a due process error because the state conceded that, in fact, the trial court judge should have granted you the Huff hearing.
Respectfully, I think that is a given. I think that has been decided that if you don't provide a Huff hearing to a defendant in an initial, that it is a due process violation. I think that's what Huff is all about. So I think that issue has been decided. I think the reason that we're here is because of all of the reasons why the court is required to hold Huff hearings and why the rule requires it. So this court shouldn't have to decide that it's necessarily a due process violation in this instance. I think this court has already said that through Huff and however many cases there are that support that a defendant is entitled to a Huff hearing. If there are no additional questions, I'm happy to reserve the rest of my time. I know I haven't used all of my time, but if the court doesn't have any questions, I'm happy to reserve the rest of my time, and I would ask that the circuit court's order be reversed and it's sent back for a Huff hearing and a full proceeding in circuit court.
May it please the court, Lisa Marie Lerner with the Attorney General's Office for the state. The state does concede that it was error not to hold a Huff hearing in this, but we maintain that error was harmless, given the...
How is it harmless if the state concedes also, and I think I read its brief to concede, that an evidentiary hearing would be appropriate on the ineffective assistance, at least some of the ineffective assistance of counsel claims?
That's true, Your Honor.
How can it be harmless then?
Because the state maintains that this court should send it back down for an evidentiary hearing. a full Huff hearing is not required, since we did concede the penalty phase evidentiary hearing.
Well, whatever we call it, you agree there needs to be a hearing of some sort.
Yes.
And the failure to be in front of a judge live making arguments is harmful in this case. You would agree?
Yes.
Okay.
However, I did want to correct one thing. The state did not concede the Hearst issue, and the state maintains that there was no constitutional violation because of the prior violent felonies and the contemporaneous convictions of violent felonies, and that if this court does see that there was Hearst error, while the state maintains there was not, any error was harmless in this situation because the jury convicted Mr. Wilcox of 5 violent felonies in addition to the murder, and Mr. Wilcox was previously convicted of murder and armed robbery.
You had CCP too, didn't you?
Yes. There were 3 aggravators.
Have we
And-
ever held that a vote of less than unanimity is harmless error?
No, but the United States Supreme Court and this court have both maintained that any Hearst error is subject to a harmless error analysis. And a harmless error analysis...
Didn't we specifically reject that prior findings, either by the jury in this case or a prior jury that led to the aggravators, is not in and of itself harmless error?
I'm sorry, I didn't understand.
I apologize. I'm sure I was less than clear. Hasn't this court held that jury findings, 12-0, on a contemporaneous felony that qualifies as an aggravator or a prior felony that qualifies as an aggravator, is not harmless error if there's less than unanimity? Haven't we held that?
Yes, but the state maintains that...
You think we're wrong?
Yes, yes, and that the court did not do a detailed harmless error analysis in those cases.
What's the state's position about retroactivity?
The state does not believe that Hearst should be retroactive in this case. This is a pre-Hearst case, and the state has always maintained that it should not be retroactive because Apprendi and Ring were not retroactive. And in fact, a number of other jurisdictions outside of Florida have found that Hearst is not retroactive because it is merely an elaboration of Ring and Apprendi.
Do we have to reach the Hearst issue here if we vacate and send back for a Huff hearing and for the trial court to go through the 3.851F procedures?
Not necessarily. If the court has no further questions.
Thank you.
Just because the state conceded an evidentiary hearing on one of the multiple claims that we filed doesn't cure the due process violation that occurred here. The state's position seems to be that because they agreed to an evidentiary hearing on the ineffective assistance claim, that therefore all the other claims can just be, that Mr. Wilcox can be denied due process with regard to all of his other claims. And that's just simply not so. The case law, I think, is very clear. The rule is very clear. We should have a Huff hearing on all of these claims. I just want to be clear. I don't believe, if I did say that the state conceded Hearst, that's an error. The state did not concede Hearst.
You didn't. I think I said it.
Okay. To be clear, the state has said that there's a near certainty that Mr. Wilcox would get Hearst relief. I suppose that remains to be seen, but certainly the law as it stands today is that Hearst applies to Mr. Wilcox's case, and with a 7-5 jury recommendation, under this court's case law as it exists today, he should be entitled to a new penalty phase under Hearst. The state also relied in their pleadings on the fact that, well, saying that the denial of an evidentiary hearing or the summary denial of the penalty phase IAC claim was in part justified by the fact that Mr. Wilcox should get Hearst relief. So we're kind of in a conundrum there where, look, he either should get Hearst relief or he should go back for an evidentiary hearing. The state has conceded, at the very least, that that there should be an evidentiary hearing on it. With regard to the retroactivity and the Chief Justice's question about retroactivity, the state has never raised retroactivity as a defense in this case to the Hearst claim. Not in the 3851 motion, not in their brief. I would argue at this point that retroactivity as an issue for the state has been waived, not only because of the fact that this court's case law supports retroactivity in the application of Hearst in this case, but because the state just simply hasn't raised it. They did make an argument about harmless error, which has been addressed, but I don't think it's appropriate for the state to now say that, you know, Hearst should not be retroactive when they've had an opportunity to say it all along and, you know, are just bringing it up here.
Can that be a tipsy coachman issue?
Honestly, Your Honor, I don't know. I'm embarrassed to say it, I don't know. But my concern is that this issue has not been raised, this issue of retroactivity. And again, we're getting ahead of ourselves because we need to have a Huff hearing.
So you've argued that some of the claims should not have been summarily denied, which some of the ones that the state did not concede required a hearing. You have an opportunity now to brief that fully. If we agree that looking at those claims that they should have been summarily denied, doesn't that cure any due process concern that you've had the chance to argue those issues here and get full appellate review, including an oral argument on whether or not the legal issue of whether or not those claims are properly summarily denied without an evidentiary hearing?
There are a couple of problems with that. I haven't used all of my time this morning, but 20 minutes would not be enough time to argue a Huff hearing. And it would be improper to come in here and expect to do that. This court is not a court of first instance that makes those sorts of findings. It should be done with the circuit court, which leads to the second problem, which is the reason that we have Huff and the reason that we have the rule is to prevent this very thing. I mean, we've all come to Tallahassee this morning to make this argument, and I'm always happy to be here, but this should have been done in the circuit court and not involving this court. And the expenditure of resources here, because the judge just chose not to follow the law, it's crazy. There's no other word for it. So while I understand that, you know, this court, your question is, can you sit as a court of first instance? I don't think that that's proper. I think the case law is against that. I think that this court should not be making those initial findings that are for the court.
I guess I have the same dilemma or concern that Justice Luck expressed, that it doesn't make sense to me on a straight legal issue that due process would require that you get up in front of a court and say orally what you had an opportunity to say in writing. I mean, I understand the rule says that you have that opportunity, but I don't understand.
Well, the rule is based on Huff and the cases that Huff relies on.
I'm talking about due process. Why?
Which are about due process. That's the fundamental holding of Huff. It's a due process violation for not allowing the opportunity for a defendant to be heard on his initial 3850. That's the plain reading of Huff. I mean, it's about due process.
But aren't the vast majority of errors, including almost all constitutional errors, subject to harmless error review? Under Chapman, for example.
After they've been heard.
No. Any constitutional error, forget due process, any constitutional error, isn't it subject to, with very narrow exceptions for structural errors, subject to harmless error review?
I'm reading your question as, or I'm interpreting your question as, can I file a motion, the state say that that the error is harmless, and then there's no opportunity for me to respond or to present any sort of an argument.
No, my question is simply this. There are lots of errors that happen in all sorts of criminal proceedings at any level.
Sure.
My question is, aren't those errors, whatever they may be, subject to harmless error review?
Many of them, sure,
Okay,
absolutely.
why is this one not one of those, assuming it is a due process issue and a violation?
Well, the issue is not the merits of whether or not the issue is harmless. The issue is the fact that we weren't given the opportunity to argue the merits of the motion. Huff is about...
Right, but if you couldn't win, if we determine after reviewing everything that it is conclusively refuted and your claims are patently frivolous, and let's say everybody in the room agrees with that, including you, how could it possibly be harmful? How could it have affected the outcome of the decision?
Again, I don't believe that this court that the role of this court should be to make that determination in the first instance.
Aren't we both statutorily and by case law required to conduct a harmless error review on constitutional violations?
Yes, but not to make findings as a matter of first instance where the circuit court has the responsibility to make those findings.
Even where you agree it's frivolous?
If I agreed that it was frivolous, I wouldn't be up here making the argument. So
That's a good point.
I respect the question and I understand where you're going with it, but I wouldn't have filed a claim that I thought was frivolous, and I wouldn't have come before the court to argue it. I'm happy to forfeit the rest of my time unless there are any additional questions. Thank you. Again, I would ask that the court reverse.
Thank you.
We thank you for your arguments, and we'll now move to the